Good morning. So this morning, a couple of items that I want to remind myself of. One is I have a goal for myself that I would like for us to do more of the work that the students would do and less of me talking. So that's goal number one. So prepare yourself mentally for that. And I guess that's my only goal. Never mind. So here's my task. My task is to look at Unit 3 and look at Unit 4 and think of ways that I can help bring together best practices in social studies education. So thinking about how historians and political scientists do the work that they do. So that's one of my goals is I'm looking through Unit 3 and Unit 4. I'm trying to find ways that I can incorporate historical and political thinking skills, the disciplinary literacy that we talked about last week. The second thing that I'm trying to do is I'm trying to emphasize an instructional strategy or an approach, and not necessarily an instructional strategy or approach that you've never seen before, but maybe just put something together that you can take with you that is linked to best practices in effective teaching, and it's also linked to an instructional approach that will get your students thinking deeply and critically. And so today for Unit 3, given what's gone on since the last time we met, I want to focus on interpreting the Constitution, and we're going to talk about original and living constitutionalists, and in particular, we're going to compare and contrast Breyer and Scalia. Yes? I came with 20. And then for Unit 4, we're going to look at the executive order. And man, that's complex. I was talking to Stephanie about this, and we'll do this afternoon, but I second-guessed myself in emphasizing executive orders. If you look at if you look at Unit 4 in the We the People curriculum, there is a little section that talks about some of the prominent or important executive orders that have been issued in American history. And then you start digging into what an executive order is and comparing it to an executive action or an executive memorandum. And the rabbit hole is about as deep as it can possibly go. And we'll talk a little bit about that this afternoon. And I've got some supplemental information that I put together because a lot of the conversation, of course, right now is around President Obama's use of the executive order. And in fact, his decision with the DREAM Act with immigration was not an executive order. And his actions with regards to gun ownership were executive memorandums and not executive orders. And so this is something that I have been learning as I've been researching it. It's pretty fascinating, the difference between a memorandum, an action, and an executive order, and how and why presidents might use them differently. So while your students are asking some of those questions, we'll talk about it this afternoon and see where we can go. The first thing that I wanted to say, and I'm going to try to make this fast because I'm already talking more than I said I would. Is there anybody out there who numbers people, quantitative communicators? Okay. Qualitative communicators, words people? Now, of course, inductive and deductive reasoning are both important, but when you think about the scientific method and you think about quantitative inquiry, we start with a hypothesis. That's hard to say at 8:30 in the morning. We start with a hypothesis, and then we collect data, and we try to find evidence to support or refute that hypothesis. And quite often in teaching, you can see the top paragraph. When we teach deductively, we introduce our students to topics by lecturing them on topics, giving them that information, and then try to encourage them to use the things that we have told them and apply them and demonstrate mastery. What I want to focus on today in particular is a more inductive approach where students do a lot of exploring and they do a lot of data collection, and then the theories and the ideas and the themes and the principles emerge from the research that they do. You can see this bottom section. Instead of beginning with general principles and eventually getting to the applications, the instruction begins with a set of observations or experimental data to interpret, a case study to analyze, or a complex real-world problem to solve. And and I have this article if you want, I don't know, I'll have Stephanie upload it, that gives a lot of research data to support the effectiveness of using an inductive approach. Now, both have their purposes, but there's a lot of interesting research to show that students actually retain the information longer and at a greater level of complexity when teachers use inductive teaching approaches. So what are some of those approaches? You're probably familiar with most of them. I'm not going to zoom in because I told myself I would not talk about each one. But guided inquiry, problem-based learning, project-based learning, discovery learning, and case-based learning. And maybe the next time we meet, we'll look at an example of problem-based learning. And when I talk to teachers and I talk to future teachers, this is a little bit intimidating because with an inquiry approach, students are developing questions, students are pursuing lines of argument and reasoning that they themselves determine to follow, and it involves a lot of us giving up some of the control about the process to students. And I know that at times I find that intimidating because I want to be in control and I want to have things set the way that I want to have them. So this is just asking you to think about a different way that is equally as effective, if not more effective. In case-based learning, which is why today we're going to focus on interpreting the Constitution, and we're going to focus in a little bit specifically on one particular case, Roper versus Williams. But before we get to that point, we're going to do some practice. I'm already talking longer than I told you I would. It's the second time I've said that, and it's on video, and now everybody in the world is going to see me repeat myself. I just about made a comment about a political candidate that repeats themselves, but now apparently they're all repeating themselves and are reminding each other that they're repeating themselves. But when we do case analysis, a case study analysis, this is a pretty generic step-by-step approach to a case-based analysis. You review the content, state the problem, collect relevant information, develop alternatives, evaluate those alternatives, select a course of action, and evaluate solutions. Case-based learning and problem-based learning are both inquiry-based approaches to teaching, but there are subtle differences between case-based learning and problem-based learning. With case-based learning, the teacher typically has an outcome. We have a place where we want students to go, and we're going to use specific cases to teach those principles and help our students get to that point. With problem-based learning, we may not have a specific end destination. We may not have a place where we expect students to go because we don't know where they're going to go. We may not know the answer to the question that they're asking. For example, we could do a problem-based learning activity where we look at the use of the presidential executive order. And I would discourage you from getting on YouTube and searching executive order to try to find a video to help your students get a visual understanding of an executive order, because you won't find one. You'll find about 75 pages of people talking about President Obama preparing to issue an executive order declaring martial law to take over the United States and eventually the world. That's what you'll find. And I know that because I just did it. So good luck with that. And I found it incredibly difficult to find scholarly analyses of the executive order because in the last 8 years, President Obama is using executive action in a way that presidents haven't used it before. And it's within the bounds of the Constitution, at least up until this point in time. And he's a constitutional law professor. And it's fascinating. I'm not making any kind of judgment or political statement one way or the other. It's just, it's a fascinating shift. And it's hard to find any information out there on the legitimacy of it. There's a whole lot of Glenn Beck on one side and somebody else on the other side saying how they feel about it. My point is this: in problem-based learning, when you give students a question and they start to investigate, they may come to a conclusion that you don't know the answer to because you yourself haven't been privy to that kind of research. So today what I want to focus on, what I'd like to focus on, is interpreting the Constitution, I know everybody in here teaches their students the ways that we can interpret the Constitution. I want to use interpreting the Constitution and how it's interpreted as a springboard to get your students to analyze specific case studies. And the document packet that I gave Stephanie to upload to our site has a couple of briefs in it, complete briefs. It's on there right now. And it also has a link to a website that has briefs of prominent cases in Word documents that are easy to read, that are written for middle and high school students, and it's phenomenal. And I would encourage you to use it, and the link is in one of the documents that I gave Stephanie. The packet that I gave you is the student handout, but I have a teacher's guide that has a lot more information for you that you can access. I just didn't want you to have it right now. But here's my ultimate goal, is for us to look at how we interpret the Constitution, to wrestle with that process, and ultimately use a case to try to come to a conclusion as to which way we should do it. And I was, as I said, inspired to use this specific example by, I shouldn't say that I was inspired by Scalia's death, because that sounds bad. I was inspired by the current controversy and debate over whether or not President Obama should or shouldn't, or be allowed to or not be allowed to appoint somebody to replace Scalia. So in the very beginning here, I know everybody here has seen this. I like to start any lesson that I teach students with meaningfully, and I'm sure you're familiar with the primacy-recency effect, the research that shows that individuals will tend to remember more of what happens in the beginning and the ending of an experience than what happens in the middle. When you're in a car accident, you tend to remember going into the accident and coming out of it, but the actual accident itself is not as memorable. Teaching a lesson is no different. Students are more likely to remember what happens in the first 3 to 5 minutes than the last 3 to 5 minutes than anything else. I had a student teacher once, and I taught them this, and he was really concrete and literal. And I told him, I said, you never let the bell end the lesson. You end the lesson. You end the lesson meaningfully. And so I pounded this into his head. I'm watching him student teach. The first time he student teaches, he's in the middle of talking, the bell rings. Afterwards, I said, remember, you don't let the bell end the lesson. You end the lesson. You remind students what your objectives were. You ask some questions and determine whether or not you were successful, and you move on, but the bell doesn't end the lesson. He said, okay. Came back to watch him teach again. Next week, he's talking to students, bell rings, and now I'm starting to get a little bit frustrated. Third time I came to watch him teach, same thing. I pulled him in the hallway, and I said, okay, what is going on? He said, I'm really confused. He said, when the bell rings, the class is over. The bell ends the lesson. And he had totally not understood what I was getting at. This is the struggle that I face. You faced your own struggles. I have my own battles to fight. I said, of course the bell ends the class, but you end the lesson. Oh, I failed in that instance. But meaningfully beginning and ending the lesson. So I like to start with questions or with images or with something that's going to startle my students and get them thinking. So I show them the First Amendment to the Constitution, specifically focusing on speech here. And then I ask them a question. Based on the First Amendment, should this be legal? How do your students answer that question, or how do you answer that question? Based on the First Amendment, should this be legal?
I posed this to my sixth graders,
Mm-hmm.
and they said, my first one talked about my country, he said, no, we shouldn't do that, that represents our country, this mess, and then we went to the amendment and said, well, isn't that fair free speech? And they were, the look on their faces like, everything has changed, I don't understand.
Right.
So they were, at this point, they're not ready to process what to do with the information that might go against what they believe.
Yeah, and 11 and 12-year-olds are as concrete as that 22-year-old I was just talking to you about. Sometimes they stay in that place, which I'm not saying they can't, but it's just very concrete in their thinking.
I think whether we like this or not, the Supreme Court has ruled on this interpretation of the First Amendment protections for stuff.
Mm-hmm.
So sadly, I adamantly disagree with that, but
Right, now, and when you introduce this to your 12-year-olds or your 17 and 18-year-olds, they more than likely don't know that. So they're not familiar with the case law. And so I'm trying to challenge them to look at the words of the Constitution and make a decision for themselves based on what they see. And then, of course, we're gonna get into the case, not in great detail, but use this as a springboard to get people, I mean, because what this does, obviously, with you and with many others, it begins an emotional journey to wrestling with what this means and how complicated it is. I included a couple clips here. This one on the right is a clip from C-SPAN, and we can watch the first 2 minutes of it, maybe. How about that? This clip, there's a documentary that came out recently on the attorney who defended Johnson in this case. And so this is about a 5-minute clip of the Johnson from Texas v. Johnson talking about the case in retrospect. The clip on the right is from C-SPAN. Have you all seen this? This was in 1980, I want to say 1988 or so, 1989, right before the Supreme Court, right after the Supreme Court rules. And so I'll show you the first 2 minutes because he explains the situation.
Well, this black man took place at the Republican National Convention, Reagan was being nominated. The whole express theme of that convention was new patriotism, bringing America back, prouder, stronger, and greater. And I think this is a theme that the government has been trying to rehabilitate in the people around since the end of the Vietnam War. And patriotism is a nasty word. Millions of people throughout the world hated the United States for the Vietnam War. Millions of people in this country came to hate this government and the patriotic indoctrination that they were put through from kindergarten to boot camp and then set off to Vietnam to commit. Many of the soldiers that came back from the war came to see it as a genocidal war in which 2.5 million Vietnamese people were murdered. In 1984, the Republican Convention was right around the time of the U.S.'s invasion of Grenada. Reagan's little jokes about having outlawed the Soviet Union, the bombing was going to begin in 5 minutes. The threats against Nicaragua to say uncle. So we wanted to do as much as possible to pierce the whole chauvinistic, rainbowistic atmosphere around that convention. And I think the flag did that very sharply.
Good evening. Welcome to our discussion. Our guest this time is Gregory Johnson, the defendant in Texas v. Johnson, the Supreme Court flag burning case. If you have a question or a comment for our guest, our phone lines will be open to you in just a moment. If you're calling from the Eastern or Central Time Zone, you can reach our studios by calling 202-628-2525. If you're calling from the Western Time Zone, you know to call 202-783-2727. We'd particularly like to remind you that if you've reached C-SPAN within the past 30 days, we'd ask you not to call during this program. Mr. Johnson, what is your reaction to the Supreme Court's 5-4 decision upholding your right to voting flag?
Well, I think it was great. Basically, I think the Supreme Court was in a position where they were forced to back off. I think they got caught in a bind where, had they ruled against me, it would have been very blatant to many people in this country that I was being suppressed and imprisoned precisely for making anti-patriotic statement with the flag. And I think that's something that would have been very disturbing for millions and millions of people. I think the Supreme Court got caught in somewhat of a bind. It's a very delicate and sensitive issue in the world today, how different governments treat political dissenters within their own borders. So I think it was a very calculated political decision on the part of the Supreme Court.
Okay, I'm going to stop it there. Now, I like to use this case to start a conversation about interpreting the Constitution because it is an emotional one for many, and because it's a 5-4 decision. And students, we begin to have this conversation about how this is not cut and dry, that it's not obvious what the truth is necessarily, and that the people who are making the decisions, the Supreme Court justices in this case, who are voting on whether or not it should or shouldn't be constitutional, are human beings too, and they're making decisions based on their own interpretation of the Constitution. And going back to those sixth graders and a lot of the high school students that we teach, when they are so concrete and they do live in this world that's black and white and there's right or wrong, you're with us, you're against us, you're on our side or you're on the other side, to introduce the idea of gray, that complexity is disconcerting. It's disconcerting for a lot of adults that I know who need to live in that world where we know what the truth is. And in this case, the truth, quote unquote, is that there was a severe and sharp disagreement on the court over this decision, a 5-4 ruling. And these 5-4 decisions, of course, there's a lot of heated conversation. And linking that to what's going on today, why is it important that we have a conversation about replacing Scalia before the Supreme Court convenes this fall? When you look at cases like this where there is a 5-4 decision, what cases are coming up where there could be the need to have one more justice to turn the tide? So starting with Texas versus Johnson, we talk about the job of figuring out what it means, what the Constitution means belongs to judges and justices. And we often disagree exactly on what the words of any part of the Constitution mean. And the Constitution didn't come with a guide to figure it out. And I'm reminded of a Doonesbury cartoon. If some of you are familiar with Doonesbury? One of my favorite Doonesburies, it shows, I think it shows Madison and somebody else, the framers of the Constitution, they're writing things out, and they have these questions. Well, what do we do about women? Or what do we do about slaves? What do we do about this, that, or the other? And they kind of look at each other and shrug their shoulders and say, we'll let somebody else figure that out. And essentially, the Constitution doesn't come with a guide unless you use the Constitution as a guide, as Justice Scalia will argue in a minute. Okay. So we're going to spend 5 minutes doing this. And on that first sheet that I gave you, this is another example of how difficult it is to interpret the Constitution and how we have to make judgment decisions in order to do that. What I'd like for you to do is to carefully read the selected portion of the Constitution that's at the very top. And maybe at your tables, read about the 3 questions, these hypothetical elections in Iowa, and the 3 people that want to run for office. And in each case, decide whether or not you think the person will successfully appear on the ballot on Election Day. So spend about 3 to 5 minutes looking at those 3 questions, looking at what the Constitution says, and then talk about it at your tables, and then we'll come back together. This is an extra one. As you answer those 3 questions, think about what factors did you use to decide whether or not they should or shouldn't be on the ballot.
What did you say?
I said, think about the criteria that you use. So when you read that first question, Chad, should he be on the ballot? What criteria or what evidence or what influences your decision as to whether or not he should or shouldn't be on the ballot?
No, it says he plans.
Plans, okay.
There's no guarantee that he'll follow through with that plan.
Okay.
And he can end up on the ballot.
So because he's planning to, we don't know for sure whether he will. Okay. Any other comments on number 1? Did anybody disagree that they think he should be on the ballot? Mm-hmm.
I thought about that. They came to District 3. He didn't actually live there before he got on the ballot. I guess he was
Mm-hmm.
maybe it's not all.
Yes, I do remember that.
And so I think as long as he plans to do it, maybe, I don't know what the situation would be
Okay,
Michelle not one way. Like, so as long as he lives in Iowa, they he's elected.
Or does he have to be a resident by the time he can take off?
what's that?
Is it the time, does he have to live there in order to go up to Lord?
Well, what does the Constitution say?
That's just about it.
Says and live.
So if he can establish residency, so if he had mail sent to his party in Iowa,
Instead of a cotton break.
yeah, then that would establish residency, right?
Post office box.
It's kind of not right, but it's possible.
What's the answer? Will you tell us the answer?
We're still on one, right?
Yeah, we're still on one.
So the key word there, live.
Okay.
Live.
Mm-hmm.
That means add a residence, in my mind. Add a residence in the state. The man has no such residence in the state.
Is it a state issue? Does the state say, you know, this is residency, and therefore you meet that stipulation in the Constitution? Is that open to state interpretation?
Yeah.
And the key word is live.
Well, we need to move on to the other ones too, but this is precisely the point, right? It is. Well, okay. You say it's murky, and I'm hearing other people who are pretty confident that they're that they know what the answer is. Yes. Mm-hmm.
Wasn't there residency requirements to be able to vote? So shouldn't those same requirements apply to either candidate? I mean, if I can't vote for the first 3 months or 6 months after I move somewhere, like why can a candidate move in the day before?
If I can't vote for myself, should I be voted for?
Right. I got 10,000 other people voted for me, but I can't vote for myself because I've only lived here 3 hours.
I'm still in voting for the
Now, I'm not this is my interpretation. I wrote here, because there's a teacher's quote-unquote guide on the document that I uploaded, or that Stephanie uploaded for us. I wrote, although this is not a situation the U.S. Supreme Court has ruled on, Chad's name should probably appear on the ballot. He will inhabit Iowa before his possible election. As such, he would, quote, when elected, be an inhabitant of that state. All other requirements are met. But the idea here, the plan, I mean, who's going to, we could take this as, we could broaden it a little bit and say who's going to run for office in a state and then not live there. But then again, we live in a wackadoodle crazy world where people, yeah. Yeah, yeah. I don't remember that. I know, yeah.
Is that what I'm thinking of? Like he was like on
Well, of course, you
the
live down.
western side of Sioux City, which is not technically in Iowa, or something like that?
Yeah, that dates us all.
Okay, how about number 2?
We said yes because she will be 25 before her election day.
Well, I kind of,
Yeah, that's not true, that's not, she plans to turn 25 before. I'm thinking about turning 25 here next week.
Now,
So-
does
go ahead.
it come into play if she was an out-of-state student coming to Iowa, you know, as a, with regard to financial aid or tuition, she's still considered an out-of-state student who will pay the higher tuition, you know, because you can't necessarily establish residency while you were attending the school. And would that come into play with regard to this as well? But then again, it doesn't say anything about
Right.
the Constitution. The Chat v. Iowa says that as long as you live there on that day of the election, call them back.
But years ago, Robert Reagan got off the ballot because they challenged the
Yeah, who is this Robert Ray person? Okay, let's look at the last one, because we have more to talk about. So how about Desiree?
She would have to go through a court battle. She'd probably have to go all the way to the Supreme Court in order to, get that kind of.
That's an amendment situation.
Exactly. The election would be long. How would it stop by that? Yeah, exactly.
She can always write her name on it, so I mean.
Well,
She could get a question,
Give her a right.
doesn't mean that she can actually serve.
Oh. Well, let's come together and then move forward. Why is it so hard to figure out what the Constitution meant when it listed the requirements for being a member of the House of Representatives? And what clues would you use to figure out the answer?
Because it cannot interpret every eventuality. You can't anticipate all of those potential things that could happen, or the changes that could happen with the passing of time.
All right, so good.
Something I see my eighth graders struggle with is when they use the double negatives. Like, I remember this year, I break it up and down each kind of pick 5 facts from a certain specific part of the Constitution. And, so you can't live in the city you represent because she's just reading shall not be an inhabitant of the state. She's not getting. But it makes it feel blank.
Yeah. Here's some other factors that influence the words or the definition of the words. How elections have been handled in the past. What will happen as a result of the decision. What is the purpose or intent? Why was a rule or law written that way in the first place? And how have other courts and judges decided similar cases? These are all factors that we could take into consideration when making these decisions. And the list down here at the bottom comes from a conversation that Scalia and Breyer have, and we're going to watch that. It's 9 minutes, but it's totally worth it. These two, I'm not sure if you've seen this before or not, but these two, over the course of the last 10 or 15 years, have had many, many conversations. It's almost like if we're going to have a conversation about interpreting the Constitution and whether the Constitution should be interpreted with this original intent or whether or not we should take a living approach, these two were the ones who were asked to talk about it. And so there are some very good conversations between these two that you can get access to on YouTube or on C-SPAN. The example that I'm going to show you is from C-SPAN. Now, in your packet, what you have is, and I'm not asking you to fill this out, but I like to give students something to do when they're watching a video. And like I said, this is going to be 9 minutes. But Scalia is going to begin by talking about who he's thinking of when he reads, quote, "We the people" in the Constitution and what those people thought about the death penalty. Breyer will talk about how the Constitution must last indefinitely. And Breyer is going to list 6 things that judges look at in difficult cases. And I would have students write those down as he's talking about them. And both justices will outline Scalia's problems with Breyer's approach. And then we'll talk about what Scalia's concerns are. So in terms of how we interpret the Constitution, and with that, there's a couple ways that you can do this. You can just use the Prezi that I built, but I have some of the metacognitive kind of what I'm thinking when I did this in here. You can make a copy of it. So you click make a copy, and then it saves it to your Prezis, and then you click edit. You can go in and you can delete the steps that I've taken. You can either delete the text, or if I have a step, or in other words, a slide where it comes on and says ask your students to do this, you can just click X on that box and that step will go away, and then you click save, and then you can just do the Prezi without my comments in it. And if you have any questions about that, I'd be happy to help you. Or you can ask your students.
In some cases. Mrs. Scalia, why is it important to tie current decisions to the framers' views in the union?
Well, I
depends upon the consent of the governed. And you find that consent in what the people agreed to. So what the people agreed to when they adopted the Constitution, what they agreed to when they adopted the Bill of Rights is what ought to govern us. Now, the Bill of Rights is, as I have said, in a sense, anti-democratic, in that it prevents the current majority from doing what it would like to do. But in another sense, it is quite democratic. The Bill of Rights was adopted, after all, democratically. It was the people self-limiting their power. Now, the meaning of that, whether it, for example, whether it prohibits the death penalty, whether the Eighth Amendment that prohibits cruel and unusual punishments, forbids the death penalty. There is no doubt that no American ever voted for that when they voted to ratify the Eighth Amendment. The death penalty. Death was the penalty for all felonies. It was the definition of a felony. It's why we have Western movies, because horse thieving was a felony, and we wouldn't have had Western movies without that. So to say that nowadays, well, things are different, and we think the death penalty is a horrible thing, and therefore, since we think so, it's prohibited to the people. That is not being faithful to the will of the people. States are free to adopt it or to refuse to adopt it, to repeal it. But to say that there's something in the Constitution that requires that they abolish it is simply not following the will of the government.
And Justice Breyer, you've written that our Constitution begins with the words, "We the people," not "we the people of 1787." Why is that an important distinction in your view?
I think, as I've asked myself, I think it's interesting, this is a bending card. It suggests where Justice Scalia and I are tremendous agreement. I mean, members of this court are unanimous in 30 or 40% of the cases. 5-4s are only a few, maybe 25%. And those issues are typically issues, since I think that's our job, is in a sense to control the boundaries of the Constitution. We're there, it's a document that creates a government. And it was supposed to create a government that would work. And that kind of workable democracy was supposed to last a long time. But our job is to apply the words that created the government, and not just those that protect liberty, though this is an important one, we do have, to circumstances today. And we're likely to hear cases that are at the boundary. Otherwise, what's the case doing here, if the answer is so obvious? So it's hardly surprising that people don't agree on many of these cases, where there are good arguments on both sides. But now I'm getting to the question, because what you really want to know is why in so many cases are we on different sides? And that is a question I ask myself. And I think the answer in part is this. And this is why I think we both accept this document is meant to govern people from now indefinitely, they said in 1787. So it has to last. And that we read into their intent. It's there. That's what they wanted. And I read it into the meaning of the Constitution. And how do we get there? There's where we might differ. I think when we read the language in any document, whether it's a statute or the Constitution, in any difficult case, a judge will read the words, 1. We'll look at the history, 2. We'll look to the traditions surrounding the words. What does habeas corpus mean? That's 3. We'll look at precedent. That's 4. We'll look to see what the purpose or the value is underlying that particular phrase. That's 5. And we'll 6, look at the consequences of deciding one way or another through the lens of those values or purposes. I think we all do that. And I think I can characterize Justice Scalia. He's happier when he's only looking at the first four. And I'm happier when I'm looking at the last two. And when I say happier, I don't just mean psychologically happy, but that I think that by looking at those last two things, purposes or values and consequences viewed in light of the purposes, that we can better carry out that initial intent that this document will in fact govern a change in society as society changes over the course of the century. I don't want to put words in Justice Scalia's mouth, but I think my approach makes him very nervous. Because I think if he's afraid, I, or if not me, others who follow this approach, will end up subjecting their subjective ideas, substituting those subjective ideas for something objective, and that's risky. And he can confirm whether that's true or not. I, of course, think that there isn't much of a risk, that he thinks there is. Anyway, am I right that he's happier on the first?
Well, if there's a risk, I know a whole bunch of rights that have been found in the Constitution that the people never voted for. Whether you put the people of 1780 behind it or not. That's what's happened through the device of looking at the purpose of the provisions and saying we have to keep the Constitution up to date. It is meant to last centuries. Let me address the last concept. The Constitution is not an instrument of change. You don't have to change the Constitution in order for society to change. All you need is a legislature and a ballot box. Change will occur as fast as you like. The purpose of the Constitution is to impede change. Take the death penalty. The fact that the Eighth Amendment does not prohibit it doesn't mean that you must have it. If society doesn't want it, you don't need 5 out of 9 members of the Supreme Court to tell you that it's a bad idea. Individual states can abolish it, as many have in this country. And it is not a recipe for change and for progress to read new things into the Constitution. My Constitution provides for a very flexible system of government. You like the death penalty? Persuade your fellow citizens that it's a good idea. You don't like it? Persuade them to the contrary and abolish it. That's flexibility. Whereas once my court holds that the death penalty is unconstitutional, that's the end of the matter. It's no use debating it. It is off the stage of democracy, just as abortion has been put off the stage of democracy. No use debating about it anymore. Cannot be prohibited. Now, you can like that or not like it, but don't pretend that this is producing a flexible system. To the contrary, it's producing what a constitution will produce, and that is rigidity. And the people who come here asking us to define new constitutional rights come here for that very reason, because they want the right that they're interested in to exist coast to coast, in every state, without anybody voting for it, now and forever, or until we change our mind.
Okay. Going back to the document packet, in the document packet that I gave you, your students would be writing down on the left side, just as a reminder, Breyer said, read the words, look at the history, examine traditions surrounding the words, look at precedent, and then, of course, the last two, which are the point of contention, consider the purpose or values, and look at the consequences of the decision through the lens of values. Whereas Scalia, according to Breyer, prefers read the words, look at the history, examine the traditions, and look at precedent without necessarily considering the purpose or values or looking at the consequences of the decision. What are your immediate thoughts or reactions to that conversation?
I
Yes?
think what I kind of really took away earlier on the day was that they really
Absolutely. Yes?
Scalia's faith in like the will for the children and the democratic process seems to me to ignore the situation of minority groups, right? So it's hard to wait for the democratic action to happen on certain things that the democratic because it's such a small amount. It's being controlled by whatever. So it's just interesting. I mean, the logic is sound. I feel the same, 100%. But it allows certain reality of manipulation, maybe. I think that the bias
Yes?
Jumping on that, if you look at the civil rights movement, though, you have a situation, you have minority groups that are trying to create change, and as more and more people become aware of the reality of what was going on in the South, in Alabama, when people see it on their television screen, children being blasted with fire hoses, people go, whoa, hold on. And it wasn't until you had a multiracial group of people that said, no, this is wrong. We can't do this to this group of people. It's just not right. And because that's the will of the people coming together and saying, oh, it doesn't matter if they're just a part of us, Would I want that to happen to my child, as an Anglo-American? Would I want that to happen to my child? And the reasonable people come together and say, no, we can't let that. And that's, it's allowing the mind of people to become aware and to change, and not forcing that on them, like Scalia says, through judicial decision.
Mm-hmm.
We're going to force you to do this because this group of 9 or 5 of the 9 believe that it should be.
But those protections for those people are already there in the 14th Amendment. They wanted them to sit. It's already been there, but I ask for it to renew because it hasn't, to uphold what they learned.
Absolutely. And recognize this.
And I think it points out not the failure of the Constitution in any way. As Mark said, those provisions were already there. But it forced into being the protection of those rights that should have improved them. I mean, if we take a look at the civil rights movement, there's only one amendment that is associated with that, right? That covers all that. Other than that, it's all legislative or Supreme Court. But no constitutional change was necessary. It was simply giving up people angry enough that, okay, now we have to do what we said.
Well, going back to the beginning, our hope is not just to tell our students, or my hope is that we don't just tell our students, this is an original interpretation or originalist approach, and this is a living constitutional approach, but to help students come to those decisions on their own by doing this investigation. So part of this investigative process is seeing what scholars over time have said about how we interpret the Constitution. The next 2 or 3 pages in your packet are 5 short excerpts of primary sources of where different scholars or historical figures are reflecting on how the Constitution should be interpreted. And what I'd like for you to do is I'd like to take 10 or 15 minutes and have you read through these 5 documents. Document A is Chief Justice John Marshall. Document B is Edwin Meese. Document C is Chief Justice William Rehnquist. Document D is Breyer. And document E is Justice William Brennan. In each one of these documents, do you think we have time for all the tables, or do we have time? Do you want me to give one document to one table? And would that speed the process up as opposed to every table looking at all 5 documents, or how would you all like to do it? Okay, so how about we have this table look at document A, document B, C, D, and document E. And what we're doing is we're looking for evidence in that document that supports either an originalist approach or a living constitution approach. And we'll come back together and we'll compare and contrast our documents. So far, so good.